Generally, you have the department present first, and then is Gary Woodbury here?
Yes, he is.
Oh, sorry, I haven't met him yet, so I wasn't sure. And then Mr. Woodbury, they're not related as I understand it. Joshua Woodbury will represent the department. Then Mr. Gary Woodbury will present Mr. Bennett's case, and then you can ask questions of both of them, or if they call any witnesses. I guess we should ask, does anyone have any witnesses today? Okay, so you can have them make opening statements if you'd like. If not, you can just go to witnesses. But the department puts on its case first, then Mr. Bennett, and then closing arguments follow the same pattern. Since the department bears the burden, though, they get to have the last say. So what I'll do is, for closing argument, is you'll have the department present, Mr. Bennett will present, and then the department gets to go last.
Okay.
And obviously, I'll be right here if you have any questions as we proceed.
Okay, thank you, Mr. Stockton. And following a little cheat sheet we got here, we'll call the hearing to order and request that the hearing and notice of the hearing be entered into the record. And then we will start with the
So again,
Mr. Stockton.
Brian Stockton for the record. Joshua Woodbury just pointed out that we're supposed to read in the notice of the hearing under the regulation, but I'm not sure, that's part of the record, so it's in the support materials. So if you want to read it in, you can. It's on page, or I can, I guess.
Mr. Stockton, is that the
So
first?
it's
the
the April
first page?
19th, 2017 letter informing Mr. Bennett that NRS 501.1816 provides an pertinent part. If a person accumulates 12 or more demerit points, the department shall suspend or revoke any license, permit, or privilege issued to him. Our records indicate that you have been convicted of the following violation with, it says with the past 60 months, I assume it means within. And then the date of 4/14/2007, fine. I assume that this is referring to the statute under which he was convicted, NRS 503.03. No, correction, this is the statute that provides the demerit points. 503.030, unlawful possession of wildlife during closed season, 12 demerit points. And then it goes on to describe the suspension will be for a period of 3 years, and that he'll be eligible for reinstatement on May 22nd, 2020. And then it goes through the appeal rights. So, questions on that? All right.
Good morning, Joshua Woodbury, Deputy Attorney General. I represent the NDOW in this matter. And I would like to call Tyler Turnipseed as a witness. I believe, Mr. Chairman, you have authority to swear the witness in.
All right, I'm new to this, so I don't know.
Me too, sir.
I'll have the vice chairman take this role.
Turnipseed, could you raise your right hand? Do you swear or affirm under penalty of perjury the testimony you're about to give will be truthful?
I do.
I think that should cover it.
Thank you. Mr. Turnipseed, what is your position with NDOW?
I think it was Mr. Woodbury. My position is Chief Game Warden at Nevada Department of Wildlife, which means I supervise the law enforcement division, all the game wardens.
And so supervising, what does that entail? If you could give us a brief overview.
Giving direction on casework, patrol duties, that sort of thing to the state's game wardens, and overseeing some cases like this, and then of course budgetary issues, personnel issues, those sort of things for the law enforcement division.
And in that capacity, have you become familiar with the name Stephen Frank Bennett?
I have.
And what did you, or how did that come about?
Through a case in which we were patrolling in the northeast corner of the state, and when I say we, I mean some of our game wardens, and witnessed the illegal killing of at least one elk.
Was a criminal complaint filed against Mr. Bennett?
Yes, sir.
And where was that?
In Elko Township Justice Court, I believe. Yes.
If I could approach the witness. Mr. Chairman. Have you seen this document before, Mr. Turnipseed?
Yes, sir, I have.
And what is the name of this document?
This is the amended second criminal complaint in the case of State of Nevada as the plaintiff versus Stephen Frank Bennett as the defendant in Elko Justice Court, County of Elko, State of Nevada.
Is this an amended complaint referring to the case that you mentioned previously with Mr. Bennett?
Yes, sir.
I'd like to move to have the second or amended second criminal complaint admitted as evidence.
Okay.
From Mr. Bennett's point of view, that document has already been provided. The simply doesn't.
Just for clarification, we're talking about the amended second criminal complaint that was filed in the Elko Justice Court on March the 6th of 2017.
That's correct.
Sorry to interrupt, but since this is an administrative law court, I wonder if parties want to stipulate that the records provided in the supplemental materials for the hearing today, for the meeting today, just could be considered admitted. Stipulate to their admission.
I don't know that it has to be admitted to the evidence, but the question regarding this that we tend to rely on, I provided them, and I don't know why we're going through this. I have to notify that Mr. Turnipseed be a witness. The one thing that is contrary.
Okay, but I'm going to have you come up here and put your objections on the record. Sorry.
My name is Gary Woodbury. I represent Stephen Frank Bennett. My point has been that under the law and under your rules, we're supposed to be notified. Both parties are supposed to notify the other of what witnesses they intend to call. We were not notified that Mr. Turnipseed would be called as a witness, number one thing. Number two, I don't have any objection to Mr. Stockton's view that the documents that have already been provided and are in your packets, no doubt, are sufficient to constitute the evidence. We have no objection to that.
I also have no objection to any of the documents being admitted as evidence. They speak for themselves for the most part. The Department of Wildlife is tasked with putting on evidence to show its burden of proof, and we can rely, based on my explanation of the documents, why NDOW was justified in doing its demerits. I've been advised that the preferred method would be to provide someone from NDOW and explain their procedures and how these things were arrived at to get more, more flavor and background on the issue. But I think we get to the same point with just a legal explanation of the facts or of this issue. I don't think we have factual issues here. It's as Mr. Woodbury has stated, I believe, a legal argument of whether NDOW was justified in actually making the demerit determination and whether the plea agreement would prevent that. Mr. Turnipseed is a representative of the Department of Wildlife. The Department of Wildlife has the opportunity to present its evidence, and him as a person most knowledgeable of Nevada, or the Department of Wildlife, is representing the position and views of the department in this case. So the specific notification of Mr. Turnipseed was not identified, but he's representing the entity that is presenting the evidence now.
So you have an objection before you. The general procedure is for the chairman to decide how to rule on an objection. So you essentially have Mr. Bennett's objection to Mr. Turnipseed testifying. And under law, we don't let people surprise other people with evidence. You usually have to let people know what's happening. I was looking up our rules on witnesses, but I didn't quite get that far yet. But usually the three things that courts will do is they'll either allow a continuance to prevent unfair surprise. So if Mr. Bennett's counsel feels that he's been unfairly surprised by Mr. Turnipseed's testimony, he can request a continuance to be able to prepare for that. The other thing is to obviously allow the witness or exclude the witness. So those are kind of the choices.
Now, is this a decision that I make solely, or do we as a commission make this
Since it's a
decision?
procedural question, the chairman generally makes this decision, but I guess if you wanted to,
I guess, in my opinion, if we're going to
consult
have,
with your vice chairman.
if we're going to have it presented to us, the facts in the case, the department is presenting their facts, so I don't see any reason why Mr. Turnipseed couldn't
Okay. All
go
right.
forward, unless asking your legal advice. I am definitely not an attorney in this matter. This is not way above and beyond my role as a chairman of the Wildlife Commission, I feel, but
So let me ask Mr. Bennett's counsel if he's requesting a continuance for this matter.
My position is that you all have a bunch of rules in place that say that each side has to notify the other side of who their witnesses will be, and you didn't do it. If you want to not abide by your rules, okay, we can accept that, and we'll let the administrative law judge decide whether or not you have to do that. If your counsel is telling you that it's okey-dokey, go ahead.
Mr. Woodbury, what statute or administrative code section are you referring to that says the department needs to identify its witnesses?
All you have to do is read the letter from Mr., I don't think he's here.
Mr. Robb?
That tells you what your procedures are, and your procedures are that each party has to notify the other side of the witnesses.
I also expect that somebody representing a party in a contested proceeding, when they're going to make reference to statutes or rules, can cite to the decision makers the rules or statute upon which you're basing your objection. That's not an unreasonable request.
It's a little bit unreasonable when we come in here and get surprised with a witness we didn't know was coming. Read the documents in your file.
I have, all of them, and I'm certainly not surprised that a member of NDOW's law enforcement would be explaining how they assess the 12 demerit points. So I think it's a bit disingenuous to suggest you were caught by surprise that someone would come in and explain the decision that the Department of Wildlife made in assessing the 12 demerit points that result in the revocation of your client's hunting and fishing privileges.
May I explain to you that this doesn't have a thing in the world to do with a decision the Department of Wildlife made. It has to do with a plea bargain agreement, and it has to do with the statute in the state of Nevada that governs it now.
So you're not challenging the decision that the Department of Wildlife made? Or are you saying they were precluded from making that assessment based upon the plea agreement?
They were precluded from making that assessment based upon the plea bargain agreement and based upon the statutes 501030 and 501385 in the state of Nevada.
What in the plea agreement says that the state will not assess demerits?
I you're changing the procedure substantially, and I don't know that you ought to resolve the first one first. Whether or not the other Mr. Woodbury is going to go forward in this terms.
And, I agree with Commissioner Johnson's assessment that nobody's being taken by surprise by having Mr. Turnipseed present testimony about their procedures. That being said, I do think, again, this is a narrow legal determination of whether the plea agreement precluded the ability of NDOW to assess demerits. And so, since it is on a narrow legal argument, I'm prepared to, if it would, foreclose further objections, just address that personally for the commission to consider.
If you're,
If that's how the commission would.
that is fine. I think that would work better, and it would move us forward. Thank you, Mr. Turnipseed.
Thank you, Mr. Turnipseed. And I'm moving under the assumption then that all the documents that were provided in the packets are going to be admissible evidence. Is that correct, Mr. Woodbury?
I have to say that again.
That all the documents that have been provided in your packet are admitted into evidence? So the first document that I refer the commission to is the amended second criminal complaint dated March 6, 2017 in Elko County. On page 2 of that amended complaint is count 1, the only count that was charged against Mr. Bennett, and that is possession of wildlife outside of open season, a misdemeanor defined as by NRS 501-385 and NRS 503.030. As that explains, Mr. Bennett was charged with possession of a bull elk, which under the NAC is a large game mammal, classified as a large game mammal. And so the charge is possession of the bull elk by Mr. Bennett. Subsequent to that document, there was a plea agreement entered, which is also in your packets. The memorandum of plea agreement is dated February 28th, 2017. And I'm sorry, I say subsequent to, there was an initial complaint filed, and after the plea agreement, the second amended complaint was filed, demonstrating that count that we just saw. So the February 28th, 2017 memorandum of plea agreement says that in the first sentence, I hereby agree to enter a plea of no contest to one count of possession of wildlife outside of open season, a misdemeanor in violation of NRS 501-385. Now, NRS 501-385 is a statute that assesses penalties under the title that these NRS 501 is operating under, Title 48. And it provides for the assessment of misdemeanors and some criminal penalties. And so that is the kind of penalty enforcement statute that's being applied here. But he also says, I hereby agree to plead no contest to one count of possession of wildlife outside of open season. And that refers to the NRS 503.030. If we go back to the second amended complaint, both of those statutes are there. So in count 1 it says, as defined by NRS 501-385, which again is the enforcement penalty mechanism, and NRS 503.030, which is the definition of possession, unlawful possession of a big game mammal. And so in this plea agreement, he's pleading guilty to, or no contest to both of those statutes. After the entry of the plea agreement, another document you have in your packet is the memorandum of sentencing in the Justice Court of Elko Township, County of Elko, State of Nevada. That document states in its first sentence, "You, Stephen Frank Bennett, have pleaded nolo contendere, no contest to the following misdemeanor offenses: possession of wildlife outside of open season." So again, that's identifying.
I just can't find the document.
Oh, you can't find the document? I'm sorry. It looks like this.
Yeah, I had it in my packet. It's the memorandum of sentencing. I think it was right after the transcript from the actual sentencing, but I reordered mine.
And I'm sorry, I've reordered mine as well. They don't have page numbers on these consensual.
But the memorandum of sentencing was included in the packet.
He has it.
I found it.
Thank you.
Thank you.
And so I just point out that first sentence as well identifies a no contest plea to the offense possession of wildlife outside open season, which is NRS 503030. And there's also a case summary that looks like this. I believe it's near the memorandum of sentencing in the packet. In that document, down about half page, it says, "Filed charge, amended formal complaint, number 1, NRS 503030, which again is possess wildlife after end of open season." And it identifies a misdemeanor. If you go down, it says count history. There was another count that was not charged. Then you follow down a little further, it says Bennett Stephen Frank defendant, plea nolo contendere, no contest. So that's, again, identifying Mr. Bennett's plea of no contest to the 503030 unlawful possession of an animal. Now, if we could go back to the memorandum of plea agreement. Excuse me, I'm looking. The position I believe that Mr. Woodbury will point out is that in the plea agreement, there's a statement that no civil penalties will be assessed. And the contention will be that the demerit points constitute a civil penalty, and that because the state agreed not to seek civil penalties in this matter, that the demerit points should not be assessed. Now, NRS 5013855 addresses civil penalties. And in general, civil penalties are monetary fines that are assessed. Black's Law Dictionary definition of civil penalties is the same. The civil penalty is a fine assessed for a violation of a statute or regulation. And it gives an example. The EPA levied a civil penalty of $10,000 on the manufacturer for exceeding its pollution limits. So that's a legal term of art. A civil penalty is a monetary fine above and beyond what a criminal penalty might be. NRS 5013855 addresses civil penalties under the scope of that statute, and it follows the same method as the Black's Law definition of a civil penalty, and it outlines specific monetary penalties that may be assessed when criminal violation is also found. In this instance, 501-3855 subsection 1A, or excuse me, 1B says, except as otherwise provided in paragraph A, unlawfully kills or possesses a big game animal, and then it goes on, would be subject to a fine of less than $250, or not less than $250, but less than $5,000. So in this case, a potential civil penalty that could have been assessed for unlawful possession of a big game animal would have been an assessment of between $250 and $5,000 in a civil penalty fine. And that was not assessed. In the plea agreement, it says that wouldn't be sought, and it wasn't sought. And the memorandum of sentencing mentions or doesn't identify a civil penalty because there wasn't a civil penalty given. However, NRS also provides that in NRS 501.8.1814 for a system of assessing demerit points for wildlife convictions. And section 1 of that says the commission shall establish and the department shall administer and enforce a system of assessing demerit points for wildlife convictions.
What was that statute again, Mr. Woodbury?
NRS 501.1814.
Thank you.
And so upon conviction involving wildlife, such as the one that Mr. Bennett was convicted of, unlawful possession of a big game animal, under NRS 501.1814, the commission administers and enforces a system of demerit points. And I guess the following section, 501.1816, talks about the accumulation of demerit points and at what point suspension or revocation of privileges or hunting licenses are taken into effect, and that's at 12 demerit points, as explained under an NRS 501.1816 subsection 2. But to get to an explanation of how, what the demerit points accrued for a specific violation are, we have to go to the Nevada Administrative Code. And in NAC 501.200, it says a person who is convicted of a wildlife violation will be assessed demerit points pursuant to the following schedule. And then it has some subsections, and the second subsection is unlawful possession. And the second line item there is unlawfully possessing big game animals during the close season, and it references NRS 503.030, which is the statute we've been dealing with this whole time that was in the second amended complaint for unlawful possession of a big game animal. It was in the memorandum of sentencing. It was in the other court document demonstrating the plea that had been entered, 503.030, and it identifies 12 demerit points as a penalty for a conviction of that statute. So bringing that all around, we have a conviction, a no contest plea to unlawful possession of a big game animal, which is under 503 or 503.030. Under the NACs or under the NRS, it provides that when there is a conviction, there is a demerit system that NDOW is to enforce. Under the NACs, providing for the demerits when we're in that event, that there is a criminal conviction. The 503.030 merits 12 demerit points, and when you arrive at 12 demerit points, there is a suspension or revocation of privileges or hunting licenses or permits, and that's where we find ourselves. There are other procedural notifications that have to be sent out, and we can go into that if Mr. Woodbury contests that Mr. Bennett was properly notified. But it's the position of NDOW that the plea agreement did not mention demerit points or not seeking demerit points, that civil penalties are not the same as the demerit points that are at issue here. A civil penalty is a an additional monetary fine, which was not sought by the DA in Elko and was not assessed, and that NDOW was justified in assessing those demerit points and thereby suspending Mr. Bennett's hunting privileges for 3 years.
Mr. Woodbury, just to clarify, the department does not impose the civil penalty. They ask the court to impose that?
That is correct. Typically, that's something that, as the individual is being charged, that the DA will go after, the court will collect. I understand that there's one jurisdiction